So as people know, here in the second part of the course, we're all about identifying limitations and shortcomings in the conventional civil action and looking at what the system does, what tools it deploys to try to respond to those limitations and shortcomings. And one of the limitations of this is that it's built on the assumption that parties have a major personal stake in whatever it is that they're litigating about, right? Because it's only parties, corporations or individuals who have something important to them personally involved who would find it worthwhile to undertake all the expense and stress and time of the conventional civil action. So everyone, the standard assumption in the conventional civil action is that everyone who has direct personal interest is identified in the pleading stage and brought into the action, and only those who have that direct personal stake are brought in. So we need an alternative route to justice when that is no longer the case, right? When there's some sort of public interest that goes beyond the interest of the people who are the most obvious parties, or where there's someone else who wants to be involved despite the fact they have not been brought in, right? That's another assumption of the conventional civil action, is that either you're the plaintiff and you've commenced this action, or you're a defendant or a third party, and in that case you've been typically brought in against your will. What do we do when someone actually wants into that courtroom even though they're not the plaintiff? So the overarching themes that kind of unify the cases we're looking at today are these questions of opening the litigation process to parties beyond these sort of standard parties that we expect. And what is gained and what may be lost when we open the doors to the courtroom more widely. Okay, so we're actually going to start with the last case that you read for today, which is this one, the case of Canada versus Downtown Eastside Sex Workers United Against Violence Society. Okay, so this was a challenge to the law circa 2012 about sex work in Canada. The old law circa 2012 said that selling or buying sex is not illegal, but there were these three prostitution-related offenses in the criminal code. First of all, Section 210, keeping a common body house. Section 211, transporting a person to a body house, and Section 212, procuring. So these laws, as they were at the time, made criminal many of the things that sex workers do, not the actual act of buying or selling, but things surrounding it. So what effects did these laws have on sex trade workers, according to the people who opposed these laws?
By criminalizing a lot of the peripheral aspects of prostitution, it made prostitution more dangerous for the prostitutes themselves. And it expanded the scope of criminality to things that shouldn't be criminal in any other context.
Yes, exactly. Okay, so the first plaintiff in this case, that's what this case is about, right? It's part of the charter challenge to those criminal code provisions around sex work. And the first plaintiff here is this entity called the Downtown Eastside Sex Workers. It's represented by these lawyers who are acting on a pro bono basis trying to challenge this law. So that's what creates the civil procedure issue in this case, is the identity of the plaintiffs and the fact that the plaintiff's connection to the law that they're challenging is weaker or more distant than the connection you will usually see between someone challenging a law and the effect of that law, right? Because most charter challenges to government legislation are brought by someone who claims that their direct personal interests have been infringed by the law which they're attacking, right? Just like in the conventional civil action, you usually find someone whose rights have been personally infringed, right? So, this police officer deprived me of my rights, or this law violates my Section 15 charter rights by discriminating in the allocation of government benefits or something like that. Here, the Downtown Eastside Sex Workers Group does not allege that any of its own charter rights have been breached, right? So it's a corporation, it's a nonprofit corporation. Corporations have some rights under the charter, but corporations don't have Section 7 rights. So by definition, the Downtown Eastside Sex Workers Group cannot be alleging that its own personal Section 7 rights have been violated. What it's alleging is that the rights of its members have. So the members of the group, they say, are women, the majority of whom are Aboriginal, living with addiction issues, health challenges, disabilities, and poverty, almost all of whom have been victims of physical and or sexual violence. So it's not that this group doesn't have legal rights of its own, right? Like you can imagine the Downtown Eastside Sex Workers Group being in court in a landlord-tenant dispute if someone's trying to foreclose on its lease, or an employment dispute if it's being sued by one of its own former personal employees. Here it's doing something different. It's alleging charter violations, not of its own rights, but of the rights of these people who support it. Okay, what about Cheryl Kieselbach? Who's she, and what's her? Why is her right to bring this litigation under question? So she currently works for this group. She was formerly a sex trade worker for 30 years and was previously convicted under these laws, but she left that work in 2001, right? 11 years before this case was brought, and has no plans to return to it. And she is not, unlike most charter claimants, she is not being prosecuted under this law right now. And she's not being deprived of anything right now by this law. So why can't she, why couldn't she have challenged this law back in 2001 when she actually was personally affected by it? Because we had the same criminal code provisions in 2001, we had the same charter in 2001, but she says that it was completely impractical. She was unable to participate in the court challenge to prostitution laws when she was actually doing the sex work because of all these risks, right? We know these people are marginalized and confronted with risks of violence and exclusion from society that most people never experience. And participating in litigation while she was actually doing the work would have exacerbated all those risks. That's her evidence. Okay, but given that it's now 2012, why can't she, you can challenge legislation or you can sue someone over something that was done to you in the past, right? So why can't she challenge or sue the government now over wrongs that happened to her in 2001? The Limitations Act, right, which we know about from this course. The civil procedure prevents you from bringing claims about things which happened too far in the past, right? And any statute of limitation would bar a claim that's 11 years old. Well, I shouldn't say that. We know that some wrongs do survive a 15-year limitation period, but this would not have been one of them. Okay, so what do we have here? We have two plaintiffs who normally have no business in the courtroom, right? Who would not have access to a conventional civil action because they don't have any direct personal interests in what they're suing about. So they have to seek what is called public interest standing, right? And it's settled law that public interest standing is a thing and is a mechanism by which litigants who don't have sort of normal or private interest standing can bring that suit. But the question that the Supreme Court takes up here is, under what circumstances should that public interest be standing? And do these two litigants, these two plaintiffs, would-be plaintiffs, pass that test? Okay, so the court reviews some of the cogent reasons why we don't just hand out public interest standing like, candy on Halloween, right? What are the public policy reasons why we scrutinize claims before we do this?
You can't open the door too wide to bring everybody in.
That's right, because what would happen if we did?
Because then you'd have a lot of lawsuits.
Right, yeah, so there's a concern there about about conserving courtroom resources. They say at paragraph 27, prioritizing cases, because we know there's long lineups to get into court, right? You wait 2 years in many cases to get to a trial for something which affects you personally. And the more people we let in who don't have any personal stake, the longer that line is going to be. We don't want the courts, they say, to become like a debating society, right? So it's not like, like an online chat room or a debating club where you go and you say, well, I think broccoli is better than carrots. And then you find some other person who's had as many beers as you have and they, take the other side. I think carrots are better than broccoli, right? And you just have a great argument about it for the fun of it. That's not what litigation is about. It's an expensive, demanding thing which should be reserved for people who have real concerns affecting them. Okay, there's another point here about different ways of challenge. So even assuming that a challenge to Canada's 2012 sex work laws should be in court, this was not the only case. Anyone pick up on this from the judgment about what was the other case that was challenging the law at the time?
Yes.
Yes, exactly. Bedford, the Crown Canada Attorney General versus Bedford. Okay, so in this case, this was coming through the Ontario courts at the same time that the downtown Eastside case was coming through the BC courts. And here we have people with private conventional rights at stake, right? Amy Leibovich was an active sex trade worker at the time. And Bedford and Scott, the other two litigants, planned to return. They weren't doing the work, but they planned to return to it. So they've got skin in the game in a very real sense that the downtown Eastside workers and Cheryl Kieselbach don't, right? They claim that their life options and their choices and their risks are being affected by what they say is unconstitutional litigation. Okay, so this is relevant from an evidentiary standpoint, right? Because if litigation is not just a debating club, if it's supposed to be about real things that happen in the real world and creating just responses to that, then having a person who can actually tell their personal story is a great evidentiary advantage. And it increases the chance that we're going to get it right, because we're not just talking about abstract things, we're talking about a person who's actually lived this stuff. And that was basically the reason why they were unsuccessful at the bottom level, right? The learned Chambers judge thought that the existence of the Bedford litigation in Ontario showed that there could be other potential plaintiffs to raise many of the same issues who were in a better position to do so. They also noted another reason why they lost at the early level was because there were many criminal prosecutions under the challenge provisions, right? So there's lots of other ways for this important matter to get before the court, and to get before the court in a more conventional way with that sounder evidentiary basis that comes from a personally affected litigant. Okay, so suppose you're on the side of you think these laws are unconstitutional and have to be changed. How could letting a case like this, a public interest case, get litigated, actually undermine the progress, and undermine the ability of the system to move forward and change these laws? Anyone catch this? To sort of talk about it subtly, this case called Blais, B-L-A-I-S. The idea is that a public interest case is going to be weaker, all things considered, than a private interest case because of the lack of personal skin in game for litigants. And if it goes to the Supreme Court on a weaker evidentiary basis and they lose, the court's not going to touch that again for another 10 years, right? So in Blais, that was another challenge to the communication provision, right? So this is one of those provisions. And it was brought by someone who had purchased sexual services, and this guy brought it, and it wasn't a very strong claim, and there was no actual sex workers who were among the plaintiffs, and it was dismissed. And then that was thought to have kind of set back the process of constitutional scrutiny because it went up on a weak evidentiary basis, and they kind of lost their shot to get the courts to change the law. So there's a sense of competition, right, between the Bedford case and the downtown Eastside case, right? The lawyers who bring these cases, they generally, they have noble motives. They want to change the law, but they also want to get to the Supreme Court and have their moment to shine. And there's a sense that if one of them gets there first, the chances of the other one are significantly reduced. Okay. So on the other hand, so that's kind of the case against public interest standing here. But then the court kind of turns and looks at the other side. They say there are significant advantages that these litigants have, right? So this case is about street level prostitution, whereas Bedford was more about prostitution that occurred in people's homes. And these litigants had kind of set up the case just to cover the waterfront, right? They drafted the pleadings, so they talked about all of the different types of sex workers who were affected by these three claims. Whereas these people had to kind of concentrate on their particular lives, right? Which means that the challenge was not as broad. It didn't cover the waterfront as effectively as this one did. Okay, so those are kind of concerns about public interest standing that have to do with alternative ways of challenging it. But at paragraph 30, they start talking about the proper role of the courts and their constitutional relationship to the other branches of government. Because when we talk about public interest standing, even if there were no other Bedford, right? Even if there were no other alternative case that could bring these issues forward, the courts are not the only venue for evaluating and possibly reforming our laws around sex work, right? We have three whole branches of government in this country, right? And there's a sense here of the constitutional obligations of the different branches. And the judiciary, it's worth recognizing, is the least democratic. It's like a completely non-democratic branch of government. And when you're talking about social issues like, what should the law of prostitution and sex work be, there's a sense of competition between the judiciary, parliament, and the executive branch, because they all have a way to make decisions on this. So if we're going to let unelected judges, make these decisions, rewrite our laws wholesale, even when there's no one before them who's actually affected by the law, then do we even live in a democracy at all? Shouldn't the proper division of powers be that judges adjudicate charter claims for people who are particularly affected by them, and then when that's not the case, Parliament takes the lead. So we have when they talk about the institutional capacity of courts, let's call that part up here. Institutional capacity. Okay, so the institutional capacity of the courts. We have an adversarial justice system, right? We know that the way decisions are made in court is by having parties lead evidence, scrutinize each other, and all the motions, all the rest of that, right? It's not an investigative process. And if we're thinking about the kind of institutional capacity of the court to make a right decision about sex work or anything else versus the institutional capacity of Parliament, Parliament has a better ability to kind of strike a committee, have someone go out and gather evidence, have democratic input through elections and so forth, right? So there's a sense of how does our whole system of government work and where does the judiciary fit in? And when you're talking about a big, complicated social issue with lots of moving parts and lots of social science evidence that might draw it, that might be relevant to it, do we really want to use the adversarial judicial process as opposed to the more democratic parliamentary process, which can perhaps more actively bring in the evidence that it needs? Okay, so that's all on the table. But ultimately, they're going to come down on the side of downtown Eastside sex work, of the group, the plaintiffs that want public interest standing. So And there's a few principles here too that are important. The principle of legality includes the idea that state action should conform to the Constitution and the statutory authority, and that there must be practical and effective ways to challenge the legality of state action. So this is an argument in favor of granting broader public interest standing, because if it's important to us that the state always be acting within the law, then it follows that anyone who can point out a way that the state is not acting within the law should be allowed to come forward with that, right? It's just, the idea is that it's an inherent good that the state always be constrained by the Constitution, and we can't count on there always being some particular individual who's been personally affected. So that's an argument that pushes us towards broader public interest standing. So there's a lot of discretion involved here. You know, the question of standing has been viewed as one to be resolved for the wise exercise of judicial discretion. However, we do have these factors, and we do need some clear law. When do we grant public interest standing? We're not going to overturn Borowski. So this is the Borowski test. 3 factors which must be considered. First of all, whether the case raises a serious justiciable issue. Right? We see this very often. The first branch of the 3-branch prong test, there'll just be this like kind of smell test. Does this even seem like a serious thing you're raising? And it almost always is passed. Secondly, whether the respondents have a real stake or a genuine interest, right? Because by definition of public interest, if it's public interest, they don't have direct personal skin in the game. But we're also not going to let people in if they just they like being in court, or they want to litigate broccoli versus carrots or whatever. They've got to have something there that goes beyond that. So that real stake or genuine interest is the word they use. And finally, whether the suit is a reasonable and effective means of bringing the issues before the courts in all of the circumstances. Okay, so that's the test from Borowski that we're borrowing. The specific legal question in this case, the downtown Eastside case, comes in paragraph 3. Whether the 3 factors which courts are to consider in deciding the standing issue are to be treated as a rigid checklist, or as considerations to be taken into account and weighed in exercising judicial discretion in a way that serves the underlying purposes and law of standing. So from the way they ask the question, you already know what the answer is going to be, right? If they wanted to go the other way, because they say, is this a rigid checklist, or are we going to, weigh these things? If they wanted to go the other way, they wouldn't have said rigid checklist. They would have said, something like clear guideline, right? So we know that they're not going to go with that rigid checklist option. And sure enough, at paragraph 20, my view is that the 3 elements identified in Borowski are interrelated factors. Okay, so this is the key ratio from this case. They're interrelated factors that must be weighed in exercising judicial discretion to grant or deny standing. These factors, and especially the 3rd one, should not be treated as hard and fast requirements. Okay, so what's the big deal about this third factor? So that's this one here, right? Whether the suit is a reasonable and effective means of bringing the issues forward. Because before this case, before the downtown Eastside case, public interest standing was routinely denied on the basis that there's going to be someone else out there with a private interest who can challenge this instead. Right? They talk about this Canadian Council of Churches case, where the Canadian Council of Churches was challenging the Immigration Acts and Immigration Act provisions that made it tougher for refugees to gain entrance to the country. And the court in that case said, well, these refugees are constantly coming and they're all constantly trying to get into the country, so one of them can bring the claim. That's not to say they have to bring it alone, right? So the law prior to downtown Eastside was that these well-meaning groups that want to challenge the law and move things forward, they should do so by finding someone with a private interest and supporting them, paying their legal costs, helping them find evidence, and so on, by keeping that living human being with a private interest in the case. Okay, so now the law is that we're not going to insist on that so much. The fact that there might be some other way to bring the matter before the court is not necessarily fatal. Okay, so that's where the law is now. That's kind of the ratio that changed the law. Applying this to the facts of the case, so there's no doubt that they have this, they raise serious and justiciable issues. They have a genuine interest in the current claim. You know, in terms of all these other prosecutions, you know, because this will always be there, right? Whenever you're thinking about public interest standing, there's always going to be this sense of comparison between, well, should we get at the issues with this, or should we wait until people with private interests can bring the same issues forward? And when they do the comparison here, they say that the real prosecutions of sex workers that happen under the criminal code are not going to be adequate. They're not going to get us at all the issues. Why not? Why, if you were a judge and you want to like get a full evidentiary record, you want to consider this once, why, especially with this type of case, especially with the issues at stake here and the people involved here, why is it not realistic to wait for the prosecution cases, wait for the private interest cases? So the direct personal risk piece is there because of people who are affected. And if someone does challenge it, they might challenge only, because we're talking about 3 criminal code provisions here, right? 210, 211, 212. If the person's only challenged under one of those, then the case will go up at the Supreme Court and it'll be just, so it's like judicial efficiency, right? It might get to the Supreme Court just on section 211, and then no one will know, well, where do we stand with 210 and 212? Even though from an efficiency standpoint, we can probably, the court is prepared to deal with all of them at once, but only if someone challenges all 3 of them at once. And the average prosecuted sex worker may not do that. And there's a comparison here between being witnesses. So the motions judge said, well, if these people are willing to be witnesses, then why can't they be parties? Because a lot of sex workers did come forward and say, I'm willing to testify about how this law has affected me. But the Supreme Court says there's a distinction between being a witness and being a party, right? That just because someone's willing to testify in court doesn't mean that they would be willing to actually bring the case forward as a plaintiff. What's one big risk we've identified in this court that confronts a plaintiff? It does not confront a witness. Absolutely, adverse cost awards, right? We know that plaintiffs, like defendants, if they lose, can be held liable for paying costs to the defendant. So that's a great part of the risk that the plaintiff faces. Okay, so they're going to win. They talk about the advantage of the case versus Bedford some more, and that's pretty much that. So which one or more of these things would have reduced the likelihood of public interest standing? So this would have hurt them, right? Because if Bedford is already coming through the courts, one of the things that lets the court say, let's give public interest standing to downtown Eastside is that Bedford does not cover the waterfront, and this case is better, provides a better evidentiary basis. This also would have hurt them, right? If downtown Eastside was just, you know, they've been doing something else, or maybe they've been helping people on the streets, but they hadn't actually been doing the constitutional work before, that would have worked against them, because that would have, in terms of the second branch of the test, right? That would have harder for them to show they had a real stake or genuine interest. It also would have hurt them on the third branch, right? Because it's less likely to be a reasonable and effective way to get a proper constitutional airing of the issues if these people have no experience with litigation at all. So this would have hurt them. This would have helped them, right? Because they have to compete with Bedford, right? On these facts, you can see they're competing with Bedford about should we be allowed in. And then this also would have hurt them, would have reduced their likelihood, right? If they're just practicing, we don't go back to law school to practice fear moot, right? We don't want to use the Supreme Court for that purpose. I mean, the court is not blind to the fact that like a lot of people want to get into the Supreme Court of Canada, right? It's the big show, right? If you're a lawyer, you get in there, you get your name in the paper, and you get a lot of business, right? And it's a thrill. It's like considered a capstone achievement for a lot of lawyers to be able to litigate in the Supreme Court of Canada. So, so they got to be a little bit careful about who they open the door to. Okay, so that's public interest standing. So intervention is when someone wants to come into litigation when they have not been brought in by a plaintiff and they have not been brought in by a defendant's third-party claim. Do you remember the third-party claim idea, where so the plaintiff can name whoever they want and bring them in. They can sue multiple parties, but then a defendant can bring a third-party claim where they pull someone else in, often because the defendant says, if the plaintiff did suffer any damage, it's not my fault, it's this other person's fault, so reach into their pocket. Okay, so those are the standard ways to be brought in. Either you're sued by a plaintiff or you're third-partied in by a defendant. Intervention is where the pleadings have closed, right? So and the main cast of characters has been identified, but someone else wants to come in. So so this again is kind of like a challenge to our conventional civil action, right? Because civil litigation is not like an election or some kind of public consultation, right? Where anyone who wants to have their say is welcome to come in and put in their 2 cents. Traditionally, it's about resolving disputes between private parties about the things that affect them all. Okay, so this Athabasca case kind of shows some of the policy considerations at play. And the case arose because the government of Alberta granted a mineral exploration license, pardon me, to this Rio Alto mining group, right? To explore on a piece of land in Alberta to try to find some gold or diamonds or oil or something. And then the Athabasca Tribal Council, which is a First Nations group, they come in and they say, not so fast. This land is within our traditional treaty area. And this mineral exploration license infringes on our treaty rights. So the Athabasca Tribal Council sues both Rio Alto and the government of Alberta. And they raise these constitutional issues, which are basically about the rights of the band. Under the treaty, they bring in, what's the section of the Constitution that talks about treaty rights in particular? Section 35, exactly. So whether the Section 35 or just the treaty rights themselves have been violated. Whether if there is an infringement, whether it can be justified, and if it can't be justified, what is the appropriate remedy to grant to the Athabasca Tribal Council. Okay, enter our interloper, the Canadian Association of Petroleum Producers. So what is this CAP? What is CAP, and why do they want to be involved? That's right. Their members will be affected, right? And their members are petroleum producers. So this is basically like an industry, like a lobby group for these fossil fuel companies. Kind of like downtown Eastside, right? An entity which does not have a personal interest, right? Their corporate interests are not involved, but the interest of their members are. So, so it's important to recognize the difference between the interest of all these parties and the interest of this party, right? These three, they all have something direct personally at stake, right? The government of Alberta, they're going to be liable in damages to the Athabasca Tribal Council if it's found that the treaty rights have been violated. Rio Alto is not going to be able to do the mineral exploration that it's paid for. And of course, the Athabasca Tribal Council says, this is our traditional land, we have a treaty right to it, and now you're going to come and destroy it with all of your mineral explorations. These guys they don't have any of that, right? It's not whether or not, no matter what happens in this litigation, they're going to continue as a corporation. They're going to collect their dues. They're going to do their lobbying. Their interest is not direct and personal. Okay, so the Athabasca Tribal Council resists CAP's involvement. They say this is a narrow issue. It's about our treaty rights and it's about the mineral license, right? If there's evidence to be brought against us that our treaty rights aren't as great as we think they are, then Rio Alto, which is a sophisticated corporation with council, can do so. There's an argument about Section 35. Musa told us it's Section 35 of the Charter that's at stake here, right? So there's a dispute about the role of justification in Section 35, right? We know that charter rights can be limited on the basis of Section 1 under the Oakes test, which means that in charter litigation, you can always, there's a role for evidence about why the government needs to be doing this, right? Or why it's a reasonable infringement, justifiable in a democratic, blah, 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 right? So the question here is Section 35 the same? Section 35 is in the Constitution, it's not in the Charter. Is there a role for that justificatory evidence under Section 35? Okay, now CAP says, on the other hand, and Athabasca Tribal Council says, no, Section 35 is not subject to the Section 1 Oakes test, therefore that's not needed. Okay, so CAP comes back and they say, look, first of all, our members are deeply affected by this, right? This case will have big precedential value because any time in the future when a petroleum producing company is working on land that's potentially vulnerable to an indigenous land claim, what happens in this case will be used as a precedent, right? So our members have that deep interest. They say, we're here to help the court because we can make submissions that Rio Alto can't, right? Rio Alto, what do they want? They just want to do their exploration, or if they're going to lose, they want to settle so they can get out of paying more legal bills, right? CAP has in some ways a bigger stake in the game because they care about the precedential value. And they're not going to sort of cut and run or settle if it looks like they're going to lose. They're going to make sure the court has access to all of the information it needs to make the proper precedent. And the judge basically agrees with that. They say at paragraph 10, Rio Alto is going to be most concerned about its immediate predicament respecting the oil and gas exploration approvals. Rio Alto, the judge says, may not be in the best position to inform the court of the impact of any potential orders on the industry as a whole. It's kind of like how the individual sex workers are more concerned with their individual predicaments, right? So if we wait for prosecutions of sex workers to get the issue of the constitutionality of those provisions before the court, you know, a sex worker who's been charged with a crime has 1,000 things to think about, more important than making a fulsome case for the proper constitutional analysis, right? So here it's a very different type of person trying to get in, but it's the same kind of argument. Okay, so CAP wins, right? Paragraph 6, they may be adversely affected by the outcome here. Their members have an interest in the litigation. The point of CAP is to protect and advance the interests of its members. And they're in a good position to add something to this litigation. So they're going to be granted intervenor status. Okay, so that's same kind of policy considerations, but of course it's Alberta law. So we have another case here to kind of bring our Ontario law into this. Wow, last case of the course. That's exciting. So this case, the Canadian Blood Services versus Freeman. So this one started off as a lawsuit between Canadian Blood Services and Kyle Freeman. Do anyone know why? What is Canadian Blood Services and why were they suing this chap? This is in the paper law 10 or 15 years ago. Yes.
Because he has sexual relations with other men, and that was banned at the time. He had sex with another man after 1977 or whatever, and so he gave blood lying on that
Yes, that's right. That's right. So it's not the having sex with men, it's the lying, which they sued him over, right? Lying about it on the questionnaire. Yeah, that's right. So blood banks, they don't ask about sex just because they're homophobic. They have at least some scientific basis, medical basis for doing this, right? Which is AIDS and other bloodborne diseases, right? And their job is to make sure that the blood supply is safe. And Kyle Freeman does not take the position that blood banks can't ask about sex at all. What is his position? And of course, it's a statistical fact that men who have sex with men are more likely to have AIDS than other people, right? So that's the basis of their, why they're asking the question. And Kyle Freeman says, you should only be asking about the last 3 months, right? So he says, this is an overbroad, excessively intrusive question because if someone had sex with a man sometime after 1978, but before 3 months ago, then and they have AIDS, then that will show up in the blood test, and you can just throw out the blood, so there's no risk. Okay, so he says that this overbroad, excessively intrusive inquiry about sexual conduct violates his Section 15 rights under the Charter as well as the Canadian Human Rights Act. Okay, so that's our litigation so far. Now, here comes our would-be intervener, the Canadian AIDS Society. Okay, so this is a group formed in 1985, a national umbrella group for local AIDS services organizations, and they want to intervene, just like CAP did in our previous case. And they want full status. They want to be basically treated as if they were a party. They want to make arguments in writing and orally about how the outcome will affect their members. Right? So again, just like CAP, right? This case they say is going to have precedential value. It doesn't affect our own interest as a nonprofit corporation, but it affects the interests of our members. So they want in for the whole shooting match, right? They want to have the right to be in the examinations for discovery, the motions, and so forth. Okay, so in paragraph 10, we get a lengthy history of this organization, right? They have a long track record of being involved in constitutional litigation, as well as doing all these other good things they do. Paragraph 14, other courts have already recognized the Canadian AIDS Society as an organization entitled to seek standing. Okay, so now we get to the rule, the Ontario rule, which is Rule 13. And it allows a non-party to intervene as an added party if the person claims, first of all, that they have an interest in the subject matter of the proceeding. So interest here is not like an intellectual interest or, isn't it interesting what's happening here? It's like more like a personal interest. So something that would let you actually bring the claim yourself as a private litigant, and you're just intervening because someone else did it already. So if I say, well, no one on the left half of this room is allowed to use a computer in class, right? You sue me, but your interests are, you could have just as easily sued me, right? So you could intervene in that. That's what 13.01 sub 1A is about. Secondly, that the person may be adversely affected by a judgment in the proceeding. So you can be adversely affected. Again, we're talking about your personal interest, but maybe you wouldn't have had the right to bring it personally. That there exists between the person and one or more of the existing parties to the proceeding a question of law or fact in common with one or more of the questions at issue in the proceeding. So again, something that these people are going to be arguing about that affects you, that in just as real and personal way. Okay, so on the motion, the court shall consider whether the intervention will unduly delay or prejudice the determination of the rights of the parties to the proceeding. Okay, so here we're recognizing that letting interveners in has direct practical consequences for the existing parties. So there's a sense here that if you let an intervener in, that is not a matter of indifference for the existing parties, right? So if you are Canadian Blood Services, why do you care? Why would you oppose this? Why would you? Why are courts attentive to sort of practical consequences of intervention for you? The time and money costs of litigation, right? And these are reasons why even good old Kyle Freeman might not be too keen on having this intervener, even though the intervener is, more or less wants the same type of outcome that he does. He still might end up paying more money and having to spend more time litigating than he would in the absence of this intervener. And that's because, like, when an intervener like this one gets the right to participate in all of this, it just it multiplies the costs at every stage. So think about discovery. Think about examinations for discovery, right? Oh my God, it's so expensive and time consuming, right? You've got people in these conference rooms and they're all lawyered up and they're there for days on end asking questions to each other. Okay, so you've got two parties, that's bad enough. Throw in a third party. Well, what does that mean? That means like another couple days of someone answering questions and having the right to ask those questions to other parties. And then if they win, maybe going after you for a cost award for what they had to pay their lawyer to participate in discoveries. Motions. I mean, a motion, big source of risk, right? You tell your client, well, I think we can, probably resolve this for $20,000. But look, here comes like a motion for an interlocutory injunction or a contested discovery motion. There's another 15 grand, right? So every additional party who comes in is going to be, if they have the right to bring motions, then that's a risk of another expensive thing your client is going to have to fight about. And if your client brings a motion, they're going to be in court potentially resisting it. So the more parties, the more expensive and time consuming the whole shooting match can be. Okay, so that's kind of, those are kind of our policy considerations. Okay, so we've got a sense here of like what the competing considerations are, right? We want fulsome evidentiary records. We want to let interveners in if they're going to provide something helpful, but we again don't want to open the doors too wide. For all the reasons they identified in the downtown Eastside case, but also the simple practical monetary consequences for the parties. Okay, paragraph 34 is a good source on this. The intervention of third parties into a private dispute, in particular such a personal one like this, should not be lightly entertained. An intervention adds to the cost and complexity of litigation and always constitutes an inconvenience that ought not to be imposed on the parties except under compelling circumstances. It's a bit easier to intervene on an appeal. Why do you think that might be? What's the threshold a little bit lower if you're trying to intervene on an appeal than if you're trying to intervene at the trial level?
There's no discovery in the appeal.
Yes, none of this happens on appeal, right? So the appeals, people file facta and there's no new oral evidence except in exceptional circumstances, so the inconvenience and cost effects are much less serious. Okay, so we've got these factors on both sides. We've got a threshold test, right? So under section 13, you have to establish one of these things. And then if you do, the court is still not obliged to let you intervene. There remains a strong element of judicial discretion here. And in particular, the weighing process against the expense and inconvenience consequences. And the judge may make such order as is just, right? So again, highly discretionary language. They can say, no, get lost, even though you do have an interest. They can say, yes, you can come in and do everything. Or they can establish terms about exactly what that intervening party can do, right? So here, that's exactly what happens. right? So they have an interest. The Canadian Aid Society does have an interest. It's a public interest. It goes, so we're applying paragraph 29 here. So this is called the Halpern test for whether they have an interest, right? So this interest must be a public interest, but also one that is over and above that of the general public, right? It's not just someone who has a strong feeling about it. They have to have done more than just, lobbying and public interest work. That generally they having some connection to the legal system with regard to their issue is pretty important. Ability to give expert evidence is not enough, right? Why is that? I mean, it's because if you give expert evidence, then just give expert evidence. Be a witness. The intervention is not the only way to be involved in this case, right? If Kyle Freeman wants to say, look, this overly broad, excessively intrusive, kind of homophobic inquiry increases the. He wants to demonstrate that increases the stigma attached to homosexual people or people with AIDS. And the Canadian Aid Society executive director knows all about that, then call her as a witness. She'll be on the stand, qualify her as an expert witness, and she can lead that evidence. You don't have to let her in as an intervener with all these potentially strong inconveniences and expenses just to get her testimony. If they just want money and they want to help Kyle Freeman win, that's not good enough either, because they can pay his legal fees, right? If they've got strategic advice or they know how this type of litigation works, then let him meet with his lawyer and provide the strategic advice. So the court is not going to let you in as an intervener unless these other things you can do to help or to participate are insufficient. You need to show to pass this test that you've got something that you have to be in as an intervener to demonstrate, and something that no existing party has, right? So paragraph 32, Mr. Freeman is a gay male who does not have AIDS. So if he did have AIDS, would that make the Canadian Aid Society intervention case stronger or weaker? Weaker, right? Because then they lose that special, unique thing that they say they can bring because he's already got that. Okay, so they are basically allowed in, they fail under section 13.01. Although CAS has demonstrated that it has a direct interest in his action, I cannot conclude, this is paragraph 39, that CAS can make a useful contribution to the development of the record in this proceeding by adding them as a party to the action. However, they do get the consolation prize, which is in 13.02, right? Amicus curiae, friend of the court, where they are going to be allowed to do something, but not as much as they want. And they don't, so they're not going to get the chance to shape the record. When parties talk about you want to shape the record, as they say, that means we want to be involved in discovery. We want to have our pleading so that all these facts that we think are important get out. They can't do that, but they get this instead. And this friend of the court stuff is always tightly circumscribed and defined. So here they have to take the record as it is, no more filing material without the consent of the parties. No, you can't seek or be subject to an award of costs, which is something that the parties are often, why you would resent and see it as a risk if someone intervened in your case. Because often no one wants the intervener in, right? You know, if Kyle wanted to do this, you know, was completely on the same page as the Canadian Aid Society, and they would have developed the case together, and they would have paid his legal fees, right? He probably doesn't want them out there either, in part because of this risk of adverse cost. Okay, so we're letting them in on a strict leash, right? No material, no cost awards. Your written arguments can't duplicate what the other parties say. You can't go over 20 pages in length, and you only get 30 minutes. to say your piece, right? So they're trying to square the circle here, right? Let's let them in to bring their unique perspective, but let's put a tight leash on it so this doesn't turn into the Canadian AIDS Society show, and so these parties don't have their litigation and their interest in resolving their litigation in a time-effective, limited way hijacked by these people.